universal justice, I think, would demand that you help someone who is struggling if you're able to. But that's different than saying that particular legal justice demands that, because particular legal justice has to do with what is the proper use of force in society.
My perception is that there's a tendency to conflate justice with rights, jurisprudence with rights. Let me explain what I mean. When you study natural law, my understanding, especially via Aquinas, is that it was primarily concerned with what is objectively right. The pursuit of what Aquinas called the basic goods. He spoke about right courses of actions. There was a defective way to pursue a basic good, and there was the right way to pursue a basic good. So natural law was based on what was objectively good. At some stage, around the Enlightenment, through Hobbes and through Locke, for example, and through the Franciscan monk, William of Ockham, they came about the subject of individual rights, which is really not actually correlative with natural law, what is objectively right. So you have what is objectively right and subjective individual rights. They're two different concepts. So basically, this is a long-winded way of saying, I think we've got to be very, very careful not to conflate justice with rights, because not the same, chronologically, historically, or even philosophically.
Could you explain real quickly what you mean when you say subjective rights?
Well, yeah, subjective individual rights is just basically the rights now of the individual, which is distinct from the idea of natural law, which was basically an objectively right cause of action.
Sure. So there's potentially a couple different things going on here. One is the ancients, and this goes all the way back to Aristotle, had a concept of justice that is often called universal justice,
okay,
which refers just to right action in general. And that sounds like what you're referring to there, right, with Aquinas and natural law, right, where justice, universal, in this universal sense, justice just means being a moral person, being righteous. In all that you do. And that's a valid way to use the term justice. However, the medievals and Aristotle also always distinguished that concept of justice from more particular concepts of justice. So there's universal justice, which just refers to being a righteous person. But then there's more particular concepts of justice, which refer to giving someone their due or equity, things along those lines. And when we're talking about particular justice, that's where the issue of individual rights comes in, because the question is, well, what are people do? What is the objectively right thing to do in terms of the way that I treat other people? And what is the objectively right thing for the government to do in terms of arbitrating between the way people treat other people? And so individual rights come in at the level of legal justice, in the sense of particular justice is in regard to the legal sphere, the political sphere, is after what should the government enforce regarding what people are due. Should the government step in when someone robs you? Should the government step in when you are in need? And force money from someone else to fill that need. Those are two very different conceptions of particular legal justice, if you want to call it that. And the answer to that question might be totally different than the answer to the question if you're talking about universal justice. So for instance, universal justice, I think, would demand that you help someone who is struggling if you're able to. And this is Jesus commanding us to help the poor for the sake of the gospel, as a picture of the gospel. So universal justice does demand that we voluntarily help people who are in poverty, especially if it's at no fault of their own. But that's different than saying that particular legal justice demands that, because particular legal justice has to do with what is the proper use of force in society. What is the proper use of government on this issue?